Got it.
Welcome to the new Labor and Workforce Continuing Education Series. My name is Matt Piesold, and I am a Labor and Workforce Specialist stationed out of Kansas City. This webinar series represents an outgrowth of past collaborations between MU Extension's Labor and Workforce Development and the Department of Labor. In the past, the Department of Labor has graciously served as guest speakers for the Labor Law Series hosted in St. Louis and in Kansas City. Today, I'm here to welcome Kathy Robinson, JD, from the Department of Labor. Over the course of the next 2 months, we will offer a series of webinars that will prepare your business, agency, and organization for its legal obligations and responsibilities. And we will connect you to the resources and experts that help you navigate these complex employment obligations. I would like to also announce that MU Labor and Workforce has applied for continuing legal education credits with the Missouri Bar, and we are pursuing other continuing education avenues. Once the topics have been approved, one will be able to purchase these education units from the same registration portal that you registered for this webinar. And for a final housekeeping note, I want to inform you that this presentation will be recorded, but will be stopped for the question and answer section. Please post your questions in the chat feature or save your questions till the end of the presentation. I would like now to turn it over to Kathy Robinson and ask her to introduce herself.
Good morning. I am Kathy Robinson, and I am a benefits advisor at the Employee Benefit Security Administration with the U.S. Department of Labor. And it's my pleasure to be here this morning to talk to you about what employers and union plan sponsors and administrators need to remember about COBRA and group health plan responsibilities and fiduciary duties during COVID-19. And basically this encapsulates that a lot of places are in flux employee-wise due to budget issues. So things to remember that you always should be doing, but are particularly salient now, but also the relief that's provided under COVID-19. I want to talk to you a little bit. Well, my background is that I have been an attorney for 25 years and a mediator for 24 years. I've been a benefits advisor with the U.S. Department of Labor for 12 years. And benefits advisors do lots of different things, but primarily we do outreach presentations such as this. And this is my favorite part of my job, is to provide these outreach presentations. And if you happen to be a member of a union or a nonprofit organization, and you would like for us to come out and do an ERISA-related topic and do a presentation, we would be happy to do that for plan sponsors or administrators. ERISA obviously stands for Employee Retirement Income Security Act. It's the law over which our agency has jurisdiction, and we'd be happy to do that. Let me give you my contact information so that you can contact me to set up other presentations, or if you have a question about something that we talk about today or otherwise, or maybe just to introduce yourself. It's Kathy with a K, which is important because my email address is robinson.kathyj@DOL, as in departmentoflabor.gov. So Robinson, ROBINSON KATHYJ@DOL.gov. And my direct dial phone number is 816-285-1874. Again, 816-285-1874. But the other important thing that benefits advisors do is we have 10 people in the local Kansas City office. We cover 11 states, and we staff a toll-free line excuse me, from 8 until 4:15 Monday through Friday Central Time. And it's pretty amazing with a number of calls we take every day and every year for 10 people covering 11 states, that it's very rare that people have to wait more than a couple of minutes to have their phone call answered. And the vast majority of the time, we're able to answer the call and the questions on that, or address the situation while we're on the phone. Once in a while, we have to do research or further work to try to resolve a situation. A large part of what we do is about education, both through outreach and then also on the phone. but sometimes we actually do informal resolution with regards to employee benefit matters over which we have jurisdiction. So we take a lot of calls. Of those, we only open a small number of cases or matters that we need to perform some kind of research or informal resolution about. And our toll-free number is 866-444-3272. I want to spend just a second talking about my assumptions of who the audience is, because that differs for every presentation that I do. This time, I'm assuming that you know the basics about how to administer COBRA and what you need to know regarding that, as well as group health plans. But certain things to keep in mind, particularly right now, and then the relief that came out recently under the various acts that Congress passed, FFCRA and the CARES Act, that has provided relief for participants and employers during some circumstances, as well as providing a requirement of coverage for actually getting tested for COVID-19, as well as tested to see if you have the virus, but also to see if you have the serology testing to see if you have the antibodies, meaning that you've already had the virus. A note that I just want to make is we have pre-approved slides from our national office. So in terms of the things that are important to remember about COBRA and group health plans, those are presentations that I've basically put together from pre-approved slides from our national office. We don't have any pre-approved slides regarding COVID-19. And so that information I'm just going to give you when we get there. And frankly, when we're talking about the outbreak period and the public health emergency period and the relief period, it can be a little complicated. I think I've done a pretty good job of simplifying it, but I'll go a little bit slower. I tend to go a little fast. On that part, I'll go a little bit slower and perhaps be a little bit repetitive. And I think I've simplified it to make it as clear as I possibly can with regards to that. Okay, so I assume that you know what you're doing basically when it comes to COBRA and group health plans, and it's just the COVID information is new information. And I have come up with some what I consider to be helpful reminders or things to keep in mind as the level of employment and employees and the census of staff can fluctuate during this time. And I appreciate your willingness to hold questions until the end. Sometimes I'm going to cover the information anyway, and it also helps me manage the time. I do plan to allow a little bit of time before noon for questions, but I'm happy to stick around after noon if necessary to answer anyone's questions with regards to that. We have an entire series set up every Wednesday or Thursday at least between now and the end of our fiscal year, which ends at the end of September. The next couple of presentations, I just want to put a bug in your ear about what you need to know about group health plan and retirement plans under ERISA for compliance purposes, as well as basics about our agency, the Employee Benefit Security Administration. We offer lots of resources and have lots of things available to plan administrators and employers and service providers that can maybe make your life easier if you know about them, particularly publications. And then in addition to that, that's on Thursday the 6th this week. And then next week on Wednesday the 12th, what employers and plan administrators and sponsors need to know about wellness plans that are covered under ERISA. So I'm hoping that you'll be able to attend those as well. So without further ado, let's go ahead and get started with the topic of the day. Okay, so one thing to keep in mind, as you hopefully know, is there are time limits for deciding group health plan claims. For the type of claim, urgent care, which one of the things that I often have to remind participants of, but not really necessarily plan administrators so much, is urgent doesn't mean I have surgery scheduled for next week and I haven't received a prior approval. Urgent would be something like there's some kind of a serious medical condition where they will have some type of negative health effect that's significant and serious, or maybe death, if they don't get this care immediately or in the very near future. And so the initial claim is 72 hours for a decision to come in once that's submitted. And then once an appeal is submitted, if that claim is denied, then an additional 72 hours. For pre-service, which is what we often call pre-authorization, it's 15 days for the initial request for a pre-authorization. And then if that's denied, then the plan administrator has, if someone files an appeal, 30 days to provide a response with regards to the appeal having denied the pre-authorization originally. You'll see the asterisks for both the initial request under pre-authorization or pre-service and post-service, which basically means that's the initial time frame. You can get extensions, and there are special rules for concurrent care. So post-service, meaning they've already incurred the claim has been submitted, you have 30 days to make an appeal. There can be a 15-day extension available for that. Just the plan decides they need more time, but they need to notify the participant of that in writing. And then if that's denied, the participant can appeal, and they have 60 days to do that. Now, one of the things we'll talk about towards the end of the presentation is that under COBRA relief for participants, they have extra time frames to submit their initial claim or their appeal under COVID. So these normal time frames that hopefully we're all fairly familiar with actually are extended under COVID. Okay, external review. Under the Affordable Care Act, as you're aware, and I'll remind you, if once they've exhausted either the participant or perhaps a provider on their behalf, once they've exhausted the internal appeals process, then if the denial is based on, are you guys hearing feedback, or does it sound okay, Amy? I'm getting feedback on my end, so I'm hoping it sounds okay to everyone else.
No, someone came in, Kathy, and so they've been muted and we're good.
Okay, sounds great. Thank you for clarifying that. I appreciate it. So once someone has exhausted the internal appeals process, if the denial is based on medical judgment under the Affordable Care Act, they can request an external review. And so you're aware of that, and that would go out either if there's a federal process, it would go to an independent review organization. Sometimes it's something that applies under the Health and Human Services administered process. Certain states, there's a state process that's available. But one of the things I'll talk about, like I said, towards the end of the presentation, is that there is under COVID and the joint notice that the Department of Labor put out with the IRS, there is also relief for participants to file for external review. Not only the initial request for external review, but if the request for external review was deemed to be incomplete, then they also have a relief period available to perfect the information they make available for their claim that they've requested to have submitted to external review. Okay, and so under the group health plans, as you know, they typically have 30 days to notify a plan of a need for special enrollment or a request for special enrollment, or 60 days to enroll in a marketplace plan under the Affordable Care Act. But under the joint notice for COVID-19 relief, those timeframes have been extended as well. And like I said, in a little while, I'll go over the information provided for COVID-19 relief under the joint notice that was promulgated by the Department of Labor with the IRS. One thing that I'll just make a note of real quick while I'm thinking of it is that you're probably all aware, although it's rare, it does happen, but rarely is someone the administrator of the group health plan and the COBRA and the retirement plan, although that certainly happens, especially with small employers. But you'll notice that the purview of this presentation only includes group health plans and COBRA. And that's because the relief provided for COVID-19 relief for retirement plans basically is under the jurisdiction of the IRS. And normally, even for those matters under the jurisdiction of the IRS, there's some circumstances where we provide education related to those. However, when it comes to retirement plans and COVID-19 relief, the IRS has requested that we just refer people to them. So most of you probably only do group health plans or COBRA, but for the few of you who might do all three of those, and I'm sorry if you do, but I admire your expertise and your courage, that might be helpful for you to know why we're not covering that also as a separate presentation. Okay, so COBRA, as we all know, the Consolidated Omnibus Budget Reconciliation Act, or basically the opportunity to provide continuation coverage of the insurance someone had before they had a qualifying event that caused them to lose eligibility for coverage and coverage. So I believe we're all aware of that. Who's entitled to COBRA? Brief overview of this. The three requirements in order for it to be subject to federal COBRA, which is the law that we have jurisdiction over as the U.S. Department of Labor Employee Benefit Security Administration. And that is to be as opposed to, for instance, under employees that have employers or plans that have, or employers that have under 20 full-time employees or the equivalent over half the previous year. Those smaller ones are typically subject to whatever the state law is, sometimes known as mini COBRA, or state continuation coverage is how we refer to it. But when I say COBRA, I only mean the federal law where there's 20 or more employees or full-time employees or the equivalent over half the year, the prior year. So that kind of begs the question. But one of the reasons why it seems like, my goodness, she has repeated that twice now. Why would she do that? Because that's important. In this, one of the things that we're experiencing and noticing in the country is that a lot of employers have shed employees for various reasons. And they may think, oh, we have under 20 employees. We're no longer subject to federal COBRA. Well, there's a couple things to keep in mind there. One is that an important thing there is it's not based on how many employees you currently have. It's did you have 20 or more full-time employees or the equivalent part-time employees over half the business year the prior year, and that would be the prior plan year. And the full-time employee equivalent would be, say for instance, you had you considered full-time to be 40 hours a week, and you had 4 10-hour-a-week employees, just to make it simple. They would be the equivalent of one full-time employee. Okay, so you have to be a group health plan subject to federal COBRA. The qualifying event has to occur. I assume you're pretty familiar with what a qualifying event would be. And they have to be a qualified beneficiary. Now, I think this can be a little confusing. This is why I try to clarify this. Their beneficiary we use actually in two different ways. We typically call the employee the participant, and any dependents that the employee has on the plan with them beneficiaries. However, for COBRA purposes, anyone on the plan, including the employee and the dependents, are a qualified beneficiary. So I apologize that can be a little confusing, but that's why I tried to clarify it. Okay. So it's a group health plan, meaning 2 or more employees on it. Sponsored by a private sector employer. We do not have jurisdiction over government or over government plans, government employees, or church plans that employed at least 20 employees in the previous calendar year. And I think I just said plan year. I mean calendar year. So let me make sure I'm clear about that. And of course, as you know, because I've said it more than once, it's at least 20 full-time employees or the equivalent part-time employees in the previous calendar year, over half of the previous calendar year. Okay, so fiduciary duties for group health plans that I want to remind you of. Just briefly and quickly, and then I'll tell you why there's certain things that I consider particularly significant to keep in mind and remember and keep an eye on during the COVID issues and the issues that businesses are experiencing, especially small employers where people often wear many hats. And so there needs to be an owner or someone in charge or the head of HR, preferably someone who you can count on to be there throughout the entire COVID situation to the extent that we can count on those things, based on the advice that I'm going to give you or the suggestions that I'm going to make about how to keep a handle on everything as employees change and hats change and that kind of thing. There needs to be at least one, preferably more than one employee that is aware of who all does what to make sure that nothing falls through the cracks, particularly important fiduciary duties under ERISA, which is, of course, what we're talking about here today. But, of course, I'm sure there are many business aspects that you'll want to make sure there's at least one person or two people who are aware of who all does exactly what, so that if people are either, God forbid, get the virus or go out on maternity leave or leave the position or you downsize, that you are aware of what they do so that you can make sure that someone else can do that. And so one thing to keep in mind might be the importance of cross-training, so that more than one person, maybe that person is going to continue to wear that hat, but you don't know what's going to happen to their job or their staying there or COVID or what have you in the future. So you might want to make sure you do some cross-training in case that employee is not able to do that for a period of time or leaves the company permanently for whatever reason, that there's someone who can pick up the slack or make sure there is no slack, preferably seamlessly take on the duties that that person who left for whatever reason, either permanently or temporarily, is not able to do. Okay, so what is an ERISA fiduciary? Any person who exercises discretionary authority or control over plan assets or administration, or gives investment advice for a fee. ERISA has a functional definition, so it's not dependent on the job title or document. Basically, they have to exercise discretionary authority or control over plan assets or administration. So obviously, in what we're going to be talking about with regards to group health plans and COBRA, the most important parts would be the fiduciary duties, knowing who is a fiduciary in your company, who's exercising discretionary authority over plan assets or administration, and how to make sure hopefully more than one person knows how to do what they do. It's probably going to be a fiduciary that the one or two people that I recommend knows exactly what everybody is doing and their different job functions and their different hats, and can plan for cross-training and that kind of thing. But it's helpful to know who's a fiduciary, because those fiduciaries are held to higher standards. And I remember when I was in law school many years ago, my estate planning teacher making such a huge difference. She made such a huge deal about, that fiduciary duties are some of the very highest duties that one can have under the law, and they're held to very high standards. But again, it's a functional definition. It's not based on the job title or the documents. It's basically, if your function, the things that you do for a group health plan or involving COBRA, involves exercising discretionary authority or control over plan assets or administration, then you're considered a fiduciary. And one of the things to be careful about with some of the things that I have delineated under COVID is that there may have been someone who was a fiduciary who left, and there may have been some tasks that someone conducted, such as they were withholding the premiums for the group health plan from payroll, or they were handing out special enrollment forms, or just handing out the paperwork, things like that. But all of a sudden, that person's job, if the fiduciary over them leaves and they end up wearing more hats, if that somehow ventures into that they're exercising discretionary authority or control over plan assets or administration, meaning making decisions, interpreting plan rules, that kind of thing, they might all of a sudden become a fiduciary. Or for people listening to this, you might all of a sudden become a fiduciary when you maybe have not been a fiduciary before. And so you'll want to be very cognizant of when you are just performing like a clerical task, or if you actually rise to the level of a fiduciary and exercise discretionary authority or control over plan assets or administration, because that's a whole different ball of wax with a whole different level of obligation and commitment, and basically when you can be held liable in certain circumstances, either by the Department of Labor or by a court or otherwise. Basic fiduciary duties under ERISA to remind you of, and I'll just go over this briefly because you are probably familiar with this. To act solely in the interest of the participants and their beneficiaries, to be prudent, to pay only reasonable and necessary expenses of the plan, to follow the terms of the plan, to hold plan assets in trust or with the licensed insurance company. Okay, prudence, one thing to keep in mind there, prudence is a process. One of the things, when we get involved in a situation on an enforcement side or even on a benefits advisor side where we're trying to informally resolve this dispute, it's usually after the fact something has happened. For whatever reason, premiums weren't withheld from the paychecks, or too much was withheld, or something going on. And we look at things after the fact. One thing to always do with regards to prudence is keep documented records of the process that you used and how you deemed it to be prudent. And that goes a long way, and we give a lot of credence to that when we look at your documents to determine if they're prudent, to show kind of the thought process and what you took into consideration and how you deemed something to be prudent. Now, just by virtue of the fact that you document it doesn't automatically make it prudent, but it's something that we give a little bit of deference to. So make sure you document those things and how you deem them to be prudent. To pay only reasonable and necessary expenses of the plan. To follow the terms of the plan. It is shocking to me how often a benefits advisor such as myself will call an HR person, because sometimes we prefer to deal with the employer directly rather than the third-party administrator for the COBRA or the group health plan. And it'll be, the person at the employer that passes things on about the group health plan or the COBRA to the third-party administrator. And they're not familiar with the terms of the plan, which means basically they haven't read the summary plan description, or when applicable, the plan document underlying the summary plan description, and they're not familiar with the terms of the plan. It's very important for as many people who are in administrative positions, whether they're fiduciaries or not, to know the terms of the plan and to know what terms change from year to year. Not just the higher up, but the people who work with the plans on a regular basis. Certainly if they're ones giving information or advising employees about how to handle certain things in the plan. It's very helpful to know what the terms of the plan are. You absolutely would be shocked at the people that I talk to and their level of responsibility that are not familiar with the terms of the plan that they're administering. I'm talking basics. Okay, and then also to hold the plan assets in trust or with a licensed insurance company. Okay, this slide is key. Know who is responsible for various activities required by the plan. Now, this is always important, even when we're not dealing with COVID-19. But when we're dealing with COVID-19, you have to know who all is responsible for the different administerial or clerical even functions related to group health plans and COBRA for the reasons that I talked about before. If they're gone temporarily or if they're gone permanently, what is it that they do related to ERISA covered plans, which are basically the employee benefit plans we have jurisdiction over? What do they do? Is there cross-training? When they're gone temporarily or permanently, who is going to take over that function so it doesn't fall through the cracks? And does that person know what they're doing, either by cross-training, preferably, or by how are they going to learn what it is they need to know? Sometimes people call us and say, I've never done this before. What do I need to know? Well, obviously, 10 benefits advisors covering 11 states with many, many, many calls. And then, of course, you throw in outreach presentations and those kinds of things. And it's just not within, the scope of our job duties to train someone to do something that they don't know how to do. But we're certainly happy to help on a limited few minutes basis, telling them what publications we have available for COBRA, letting them know that we have a new model notice available, both for the general notice as well as the election notice. And just real quick, while I'm thinking about it, speaking of notices, we do have a new model general notice as well as a new model election notice, which happens to be updated for various important things, but it also is updated with regards to COVID information. So if you weren't aware that we have an updated model general notice, which, as you recall, is the notice that everyone is entitled to within 90 days of enrolling in the plan, as well as the election notice, which, as you know, is the notice once they have a COBRA qualifying event causing them to lose eligibility for coverage and lose coverage. The election notice obviously is what you send to them in order for them to elect COBRA. So we do have model notices on our website, and I will tell you what our website is at the end of the presentation. Okay, so know who is responsible for the custody of the plan assets, who is responsible for the record keeping, who makes the benefit decisions and directing investments, and who does what job within the employer, who wears what hat, how do they relate to ERISA. If that person leaves, double check what hats they were wearing. Before they leave, double check what hats they're leaving, and what kind of a plan do you have to make sure that those tasks are fully cared for if they're temporarily or permanently gone. So that's why it's so important to have at least one or two people who knows exactly what everyone does. And of course, if you have hundreds of employees, that can be difficult. But you don't have hundreds of employees typically, unless you're like a third-party administrator, that is handling COBRA and group health plan issues. Okay, tips for avoiding common problems. Under COVID, especially while staffs are typically being downsized at least to some degree, or people are leaving or what have you, things to keep in mind that are very important to continue to do well or to start doing well if you're not already doing them well. Carefully select and monitor the service providers. This is also one of those prudent aspects that I mentioned a few minutes ago. When you select and monitor the service provider, you don't necessarily want the cheapest or the most expensive. You want the most prudent for your plan and your situation and your budget. But you'll want to write down and document and keep. Doesn't do you any good to document if you don't keep your process for how you determine that the service provider that you chose was the most prudent service provider to choose. And then sometimes when their contract is up or your arrangement with them is up, you want to keep the service provider. It's important to be aware that you should undergo a prudent process at that time as well. Make sure that the things that you had checked on about them earlier, such as licensing or good reputation or what have you is still the case. And so you'll want to do some kind of a continued vetting process, even to continue with and maintain a service provider that you've already hired before and just want to continue providing. And then, of course, you want to make the required disclosures to participants and beneficiaries. It can be challenging to stay on top of these many disclosures that need to be made, and the ones that get added to those for someone who's been with you for years and does it all the time and understands that. As staff are a little bit up in the air with certain employers, it's very important for people to know, maybe have written down, preferably have written down, these are currently the required disclosures. This is when they go out. This is who they go to. And make sure that there's cross-training so that people are aware of who that goes to and when. I'm just going to make a quick note as a reminder about beneficiaries, and that is, especially for new people, and maybe this is a new hat for them and they haven't done it before. When the participants, which would be the employees typically, and the beneficiaries, in this case, we mean their dependents, such as their spouse and their dependent children, when they all live in the same home and that's what you're aware of, then you just basically send it to the employee and assume that all of the beneficiaries get it, such as the spouse and the dependents. However, these days, it's very important to keep in mind if a spouse or an ex-spouse, as it were, becomes an ex-spouse, meaning they're no longer eligible to be on the plan as a spouse, you have to allow that spouse as a beneficiary to notify the plan that they are no longer a spouse and to update their address, whether they're currently a spouse or if they're now an ex-spouse. Some plans say we only deal with the employee. You can only make changes or notifications to the plan through an employee portal, and that's just not sufficient. You have to allow beneficiaries the option of doing that. And this makes a lot of sense, particularly in the case of divorce, because of, as we all know, and I used to be a divorce attorney, so I really know, things are not necessarily amicable. They may not like each other. They may not be doing the right thing by each other or looking out for each other or taking care of each other. And so it's not usually a good idea for one ex-spouse, especially recent ex-spouse, to rely on the goodwill and responsibility of the employee ex-spouse to make disclosures and updates that make a significant difference to the ex-spouse. So you have to allow say the husband was on the plan as the employee and they get a divorce, and the ex-wife wants to call up and say, my children and I, or just me, are now an ex-spouse, so I want to notify you of that, and I want to update my address. You have to allow them to be able to do that. And then also, there are circumstances, particularly under the Affordable Care Act, where dependents up to age 26 can remain on their parents' plans on many plans, and very often they don't live with the parents anymore. And so you need to make sure that they are allowed the opportunity to have a separate address. And so when you make people go on COBRA, you want to make sure that you're not just sending the COBRA notice to the employee, but also maybe to the dependent children. I don't mention the spouse in this instance because the spouses or ex-spouses, the divorce itself is a qualifying event to allow them to be on COBRA. But they could have a second qualifying event, such as the death of the employee, that would extend their COBRA, et cetera. Okay, understand your plan and your responsibilities. And it's helpful for everybody who has duties under the plan, whether they're clerical or administrative or fiduciary, to understand the plan and their own responsibilities, whether or not your responsibilities rises to the level of being a fiduciary. And it's helpful for people to know each other's responsibilities, to be able to step in and help and do the cross-training, to make timely contributions and monitor the plan assets. And so you need to make sure that there are seamless transitions as necessary so that contributions remain timely and that plan assets are monitored. And so you'll want to make sure these things are happening and monitor these things, whether you're losing employees or changing employees or not. And then, of course, it's important to know the reports that need to be filed with the government, whether it's the Form 5500 annually for the group health plan and pension plan, or the M1 report for certain health plans, and keep good records. Document what you do. Document who the COBRA notice was sent to and when and how and where and that kind of thing, and notices with regards to the group health plan. Delegation. When assigning responsibility, whether to an internal committee, human resources department, or external service provider, make sure they understand their responsibilities and make sure this is clear to everybody. Sometimes the employer or the people within that employer that are working with the third-party administrator have certain assumptions about what all the third-party administrator is doing. And the third-party administrator or the carrier has different understandings about what they're going to take care of and what their responsibilities are. So make sure everyone's on the same page about that. I recently dealt with a situation where an employer didn't send COBRA notices out to anybody because they assumed that the carrier did that. And they didn't know that it was their responsibility to do that. And so I needed to get COBRA notices for everyone, and I helped educate them that it was their responsibility to do that and to make sure that that happened, and led them to the model notices on our website for the general and the election notice, as well as we have a publication on understanding continuation coverage under COBRA for employers, plan administrators, unions, et cetera. Make sure they have the knowledge and information necessary to carry out their responsibilities. One thing that I would put another bug in your ear about here is that, especially if they're taking on new responsibilities that they haven't done before, make sure that it's a safe environment for them to think through and ask the questions. The idea being there is no stupid question. I know, you know, ERISA can be arbitrary. It can be capricious. It can be not necessarily intuitive. And so it's important not to make assumptions. It's important to go over how it works, not how you think it should work or how it makes sense that it works or what might be intuitive, because as we know, the law is not necessarily intuitive. It's how it is and how it actually works and what actually needs to be done. And then monitor them to make sure they carry out their assignments. Record keepers. If you hire a third party to maintain your records, remember, make clear in your contract which records belong to the plan and when and how records must be maintained and made available. There is a duty to maintain records, and it cannot be avoided by contract, delegation, or otherwise. In other words, you're still on the hook. So you may hire a record keeper for your health plan or for your COBRA or to be your third-party administrator for those. Make sure the contract makes you the owner of the record, because if you fire them or they quit or however or go out of business, you want to make sure you have access to that information for current and future purposes, and then monitor the work of your record keeper. The summary plan description, we all know this, that it's the SPD, the basic ERISA disclosure document. This is what I recommend that all the people who work with your plans, whether it's even clerical duties, understand what's in the summary plan description. Must be a complete and accurate summary of the plan, including benefits, rights, and obligations under the plan. Must be written to be understood by the average plan participant. Disclosures on request that even under COVID, there are obligations to send out, even though there may be some relief with regards to the time frame for some of these. Upon receipt of written requests, you must provide the plan document, the current summary plan description, insurance contracts, other instruments under which the plan is established or operated, such as the plan trust agreement, the Form 5500 that you filed with the Department of Labor and the IRS and/or the IRS, and other miscellaneous disclosures. how you can furnish the documents. In-hand delivery at the workplace, if so, make sure you document who gave it to whom, who received it, when, what they received. You can do it by mail, by the last known address that they provided to you. Electronic delivery, subject to certain regulatory standards. And what I'll just say here is that there are pretty strict rules with regards to electronic delivery. You can't just say, I'm going to email it to you at your home or to your work email. There has to be some circumstances which allows you to do this. And they can also choose not to consent to electronic delivery. And then posting in the common area is good to do, but is not necessarily enough. Just want to briefly make you aware that we have voluntary fiduciary correction programs. Couple key points here. There's like 16 or 18 situations where you can apply to be with the voluntary fiduciary correction program if you've omitted doing something you were supposed to do, or if you did something wrong. And so you can call us, or you can look on our website to get information about that. But one of the things to keep in mind there is you want to avail yourself of that program prior to our contacting you about an issue that a participant has brought to our attention. Preferably before a benefits advisor is contacting you about it, but certainly before our enforcement unit is doing an audit or an investigation. Okay, EBSA contact information. Earlier, I had said that you could get publications and the like. Our website is not necessarily easy to navigate, but it is chock full of extremely helpful, important information, and well worth some time spent there, because God knows all of us have plenty of time to go spend oodles of time on the Department of Labor EBSA website. But that being said, it is helpful and can sometimes save time doing that. And that's dol.gov/agencies, which is plural, /EBSA, the acronym for Employee Benefit Security Administration. Sometimes the Office of Exemption Determinations is helpful to know if you need an exemption. The Office of Regulations and Interpretations, there's a number there. Hopefully everyone got a copy of the slideshow so that you have that. But also, I mentioned earlier in terms of what benefits advisors such as myself do, in addition to getting to do these outreach presentations, we not only answer the toll-free line, which again is 866-444-3272, but you can also submit a web inquiry, particularly if there are documents that are important for us to look at or have access to in order to help you. And that's askebsa.gov, I'm sorry, let me start over, askebsa.dol.gov to submit a web inquiry as opposed to a phone call. And I'll just repeat my contact information again, and that's robinson.kathyj@dol.gov, robinson.kathyj@dol, it's in Department of Labor.gov, for those of you that joined us late perhaps. And then my phone number is 816-285-1874, and you'll see our toll-free line that benefits advisor staff Monday through Friday, 8 to 4:15. There's the number there. Now I'm going to spend just a few minutes talking about the relief that's available to you because of the joint notice and some of the acts that were provided by Congress that impact group health plans and COBRA obligations. Okay, so basically, I'm going to describe the public health period, the outbreak period, and relief period. And typically, this would be with regards to when participants get extra time in certain circumstances. And I'll go over those circumstances where they get extra time here in a minute, as well as the few circumstances that the provider, the plan administrator, or the plan itself, the plan sponsor, there's some relief that's available to you as well. So basically, the outbreak period starts on 3/1 of 2020. No, I'm sorry. The relief period. The relief period starts on 3/1 of 2020. And it goes to the 60th day after the end of the public health emergency period. The original time frame that Donald Trump had put out there was 6/29. I'm sorry, was 4/30. So it goes until 60 days after the end of the public health emergency period. We are still in the public health emergency period. So they still have from 3/1 until 60 days after that in order to meet the responsibilities that they're supposed to meet or to meet the deadline. So basically, for now, this is pretty much an open-ended deadline because they get 60 days after the end of the public health emergency period. And since Donald Trump has, or someone else hasn't determined that an end to the public health emergency period has occurred, the 60-day time frame for that to end has not occurred yet. Okay, one thing to keep in mind is that if they had a situation where their time frame started before 3/1 of 20, such as they encountered something that allowed them, an event that allowed them to make a special enrollment opportunity, or a COBRA election opportunity, or a COBRA premium payment, or something like that, then you count the time frame from the date of that event or that situation before 3/1 and count that against their day. So say they got divorced on 2/15 of 20, and they have 30 days to notify the plan. But 2/15 is not a good month. We'll go ahead and use 2/15. 2/15, and there happened to have been 29 days in February this year. So they will have used up 14 days of their special enrollment period prior to March 1st. And so they get all the time after March 1st until the end of the health emergency period, plus 60 days to make their special enrollment, to notify the plan of the fact that they had the divorce on 2/15. Anything after 3/1, they basically get their normal time frame, and they get 60 days after the end of the public health emergency period. So people have some pretty long time frames with regards to certain things, and I'll go over specifically what those are here in a minute. So I've tried to take that joint notice and basically boil it down to try to make it as easy as I can for you to understand exactly what that entails. Okay, so basically group health plans, the plan administrator, the relief that you get is more time to provide the COBRA notice. And this would need to be based on COVID-19 situations that you're dealing with. Either you've had to close down, or you don't have any staff, or you have the virus, God forbid, or something like that. You technically have until 60 days after the public emergency period is declared over, but we would recommend that you do it as soon as you reasonably can under the circumstances, and then just document what's going on in your particular circumstances when you do it, and how that was the soonest opportunity that you had to do that was reasonable under your circumstances. So just document those things. Okay. So what the participants get to do is, instead of their normal time frames for certain events, during the outbreak period, which doesn't end until 60 days after the end of the public health emergency, which hasn't occurred yet, and we don't know when that's going to occur, these are the provisions that the participants get extra time on. Normally, they have a 30-day period to request special enrollment or a 60-day period to get on the marketplace. That time frame, they have relief under for COVID-19 under this joint notice, as I've been describing. The 60-day election period for COBRA, the date to make their COBRA premium payment, the date the COBRA qualifying beneficiaries have to notify the plan or of a qualifying event, such as a divorce or aging out of dependency status, which is only the case for certain plans, or of a disability determination if they're trying to get a disability extension. They have relief for the date to file their benefit claim. We went over that at the beginning of the presentation. The date to file the appeal of an adverse benefit determination. The date to file a request for external review after they received an adverse benefit determination, and they've either exhausted the internal appeals process or it falls under one of the circumstances where they can bypass the rest of the internal appeals process, etc. The date to file the request, not only for the external review, but to perfect the request for external review if the request was found not to be complete. So to provide the information that would make that complete. And so hopefully that's clear with regard to the relief provided to participants as well as to plans under COVID-19 for group health plans as well as COBRA, and some of the things that I think are particularly important to keep in mind as businesses and employees fluctuate, yet still need to maintain their fiduciary duties and their obligations under ERISA-covered group health plans and COBRA. Thank you very much for your time and attention. It's been a pleasure to talk to you about this today. If there are any questions, I'm happy to entertain questions that have either come up in the chat box or otherwise. If I need to stay past noon, I'm happy to do that. And then also, please do keep in mind, if you are affiliated with a nonprofit or a union and you'd like for me or one of my coworkers to come out and provide a presentation on a whole panoply of topics we'd be happy to talk about, please feel free to call me at 816-285-1874. Thank you very much, and I'll open things up to questions at this point.